but we will
Well, I
set
like
your
to
matter.
challenge jurisdiction right now. I have the
You
right
can
to
file an
travel.
appropriate motion with the court under the Michigan court rules to challenge jurisdiction. But what we won't do is entertain motions under the King James Version of the Bible. Okay?
That
Your Honor, but respectfully, the name in all caps represents a corporate legal fiction. I am here as a living woman, not as a surety or a fictional entity.
You don't have to be a United States citizen to be charged with a crime in the United States. And if I were you, I wouldn't go around here in open court live stream declaring that I'm not a United States citizen facing criminal action with the current federal administration.
This is the city of Detroit, Mr. Berry versus Destiny Graves, case number SB 1069059, counts 1 and counts 2, SB 172478881, SB 1724805, counts 1, 2, and 3, and SB 1724836. Appearance for the city, Mr. Berry.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Ms. Graves.
Good morning, Your Honor. I am Destiny Raven Graves. That's capital D, lowercase ESTINEY, hyphen, capital R, lowercase AIVYN, colon, capital G, lowercase RAVES. I am appearing specially and not generally. I am here in good faith and under the protest solely to address the matters raised in my plea abatement. I am not here to delay the process, but to ensure proper identification and lawful jurisdiction are established in the record before any further proceedings.
All right, good morning to you, ma'am. Today is the date and time set for arraignment on the bench warrant. Would you like counsel to represent you or no?
I'm sorry, can you repeat that?
I said today is the date and time set for arraignment on the bench warrant. Would you like counsel to represent you or not?
I actually am not open to proceeding until we establish jurisdiction over the living woman. That's Destiny, lowercase ESTINEY, hyphen, capital R, lowercase AIVYN, colon, capital G, lowercase RAVES.
Okay. Jurisdiction has been established if you are Destiny Graves. If you're Destiny Graves, if that's your name, then unless you have some other view of the court rule and you cite a court rule, the court is going to feel the jurisdiction has been established.
I understand, Your Honor, but respectfully, the name in all caps represents a corporate legal fiction. I am here as a living woman, not as a surety or a fictional entity. I respectfully require the court to establish, for the record, how to obtain lawful personal jurisdiction over me, the living woman, separate from that entity.
Well, I'm going to enter a not guilty plea on your behalf. I'm going to give you a $0 bond. I can either give you into the breakout room with the city with an attorney, and he can help you proceed, or you can proceed and speak to the city attorney yourself to see if you can work this matter out, or I can set a jury trial date and the matter will be resolved on the jury trial date. Which one would you like to do, ma'am?
Are you asking me if I would like to proceed for trial?
Yes.
I would respectfully, Your Honor, I would like to reserve all my rights under the UCC 1-308, and I object to these proceedings under protest and duress. My appearance is special and not general. I do not consent to the court assuming jurisdiction through presumption. If this court insists on moving forward without proving lawful authority over the living woman, I must note a violation of due process for the record.
Okay. So, I mean, if you can't give me an answer to my question, then I'm gonna put you back in the waiting room until you can figure it out, and we'll move on to the next person.
What is your question, Your Honor?
I asked you, do you want to see if the attorney can get you an offer and speak with the attorney? Or would you like to work out an offer with the city yourself to resolve the matter? Or would you like me to set a jury trial date? Those are your three options. You keep on saying that same stuff is not going to change what your three options are, okay? So that's that. I don't need to hear that same recitation of what you just mentioned a minute ago. Now, what do you want to do?
So I'm sorry, respectfully, Your Honor, I do want to know, is this denying the abatement plea?
Say that again.
Is this denying my abatement plea?
I'm not getting into this, ma'am. I'm going to pass the matter. All right, let's go to, what is that? You're on, Ms. Mendez.
City of Lansing versus Aaron Skates, 25-01554. Appearance, please.
We vote on behalf of the City of Lansing, Your Honor.
You are Aaron Skates? Okay, today was the date that was scheduled for hearing. I have a hinder, obstruct, oppose, pretrial, and a furnishing false information. Did you all discuss this matter and how do you want to proceed?
Your Honor, if I may, Mr. Waddell did speak with Mr. Skates before we were on the record here today, and Mr. Skates indicated that he had submitted some documents to the court, and we did not receive any documents from you.
There's been no motions filed with the court. There are some documents in the file, but that's not a properly filed motion according to the Michigan court rules, so the court does not have jurisdiction to review those.
Yeah, at this point, there was no offer made. We were giving him the opportunity to present us with some sort of documentation, but at this point, we have no motion.
Okay, they're not offering a reduction in the charge. You have the right to proceed to a trial. You have the right to jury trial. I think you declined court-appointed counsel and said you would retain an attorney. Is that accurate?
I was talking to one, but it's not really in my means to acquire the attorney.
Okay, so would you like to maintain your not guilty plea and proceed to trial, sir?
I don't consent to anything here. I can't let constitutional rights were violated. So I am on the record. My status is a Moorish American national. I am not a Black person. I am not a United States citizen. So that's why I claim my nationality as a Moorish American.
You don't have to be a United States citizen to be charged with a crime in the United States. And if I were you, I wouldn't go around here in open court live stream declaring that I'm not a United States citizen facing criminal action with the current federal administration. That was not in your best interest. I wouldn't do
I
that.
can't claim my national status on the record.
Yeah, okay, that's fine. But you're making a declaration that you're not a citizen. And we have an administration that is making efforts to make sure people who are not citizens who are facing criminal actions are deported.
So when I'm claiming my national status on the record, it's for this land here.
I recognize that this land here is known as the United States of America. This court sits in the city of Lansing, Ingham County, state of Michigan.
United States
Okay.
Federal Corporation though.
Okay.
So when I claim,
Wonderful.
I'm not
If you want to
arguing this.
maintain, if you want to stand mute, you have the right to do that. You have the right to plead guilty or plead not guilty. I recognize that you're asserting yourself as a sovereign citizen.
No, sovereign citizen.
What do you
Such
say?
a sovereign. Don't, it's confused, it's a misnomer to say sovereign citizen.
What you're asserting yourself as what?
Just sovereign on the land.
Okay.
American indigenous to the
Okay.
land.
I'm happy to hear that you're sovereign and indigenous to the land. The court will continue your not guilty plea. This matter will continue to trial, okay?
Can I get some type of documentation?
We are gonna give you the notice to appear for a jury trial. September 2nd at 8:15. September 2nd at 8:15 in person at the court, okay?
Okay. And
You need to wear a shirt that has sleeves.
I just came to work, so.
I recognize that, but I'm talking about for your jury trial. You're gonna need to be appropriately dressed, okay?
This isn't.
It is not. And I'm advising you of this on the record so that you know to come appropriately dressed for your trial. Okay? Thank you. Do you have any questions for the court at this time? Any additional matters for the record?
Nothing from the city, Your Honor.
Thank you. We'll get you a notice to appear. You're all set.
Let's get that in the mail or?
No, we're gonna get to you right now.
Okay.
On the record in the matter of the people of the city of Lansing versus Rambo L, file numbers 22L2761882, 881, 883. Council appearance, please.
Matt Staples on behalf of the city of Lansing.
Okay, and then Rambo L is present. Do you have an attorney, sir?
I'm here by special appearance.
Okay. Mr. Staples, my understanding is that you're moving to dismiss these.
Just the failure to display ops, Your Honor. I did check the Secretary of State. His license is valid, and he did show me that license, and that he does have it in his possession, so that the misdemeanor charge would be dismissed.
Okay, and there's no offer on the expired plate and the failed signal?
Not at this time, Your Honor. I believe
Okay.
Mr. L is planning on contesting those charges.
Is that correct, Mr. L?
Yes.
Okay, we'll set them for a hearing. February 14th at 9:30. Any additional matters for the record, counsel?
Nothing for the city, Your Honor.
Okay, you're all set, Mr. L. We'll see you on February 14th. Okay, is this L Rambo or Rambo L? You're muted. You have an attorney, sir?
No, I'm here by special appearance.
Okay, I'll put you in the private meeting room with the city attorney.
Your Honor, we've actually already met with Mr. Rambo L before. He was requesting a formal hearing on these two files.
Okay, sounds good. Formal hearings will be set for in-person appearance.
Actually, I filed a motion January 6th. Is when it went unanswered. I would like the court to dismiss this matter.
Okay, your motion to dismiss is denied.
How many days does the prosecutor have to answer my motion for demand for motion for challenge of jurisdiction that I submitted to the clerk, and I've served everybody, all parties? How long does he have? Because that happened January 6th.
I see it's a motion to show authority.
And also a demand for dismissal, lack of jurisdiction, failure to introduce evidence of an injury in fact, challenges jurisdiction of the court to prosecute. That was filed January 6th.
We only have one motion attached to the file. I don't see the other motions that you're referencing, sir.
It's timestamped by the court. I have it right here.
I see a motion to show authority, which the court has denied. And then there was a memo that was attached. There was not any other motion. I don't read via Zoom.
It's filed with the clerk. Everybody was served.
Mr. Staples, did you get a copy of the motion he's referencing?
I see a copy of the motion to show authority in our file. I don't recognize it as any sort of valid motion or pleadings, but I see a copy of it in our file.
Agreed. That's the same the court has. It's a motion to show authority. The other motions that he's referencing was not properly filed with this court or served as the court. Neither the court nor Mr. Staples' office is in receipt of it. The motion to show authority was denied. Is not in proportion with the Michigan court rules. It does cite, however, Luke 11:46, the King James version, Luke 11:52, as well as some other articles and treaties. But nonetheless, as indicated by Mr. Staples from the Office of City Attorney, this is not a lawful or appropriately filed motion, and for that reason, it was denied before this court. But we will.
Well, I like to challenge jurisdiction right now. I have the right to travel.
An appropriate motion. with the court under the Michigan court rules to challenge jurisdiction. But what we won't do is entertain motions under the King James Version of the Bible, okay?
That was a different motion you're referring to. That was the motion to show authority.
We don't have the other motion, sir. So you can file that motion. It's just, we don't have it. I don't know why we only have one motion, that we don't have the other one you're referencing. So you'd have to file that and serve it on the city attorney. We'll give you time to do that. I'm gonna set both of these matters for hearing though.
I can't chill. You telling me I don't have the right to challenge jurisdiction right now? I want to challenge jurisdiction right now.
You can file a motion for challenging the jurisdiction, sir.
I can't do a verbal motion?
No, you cannot.
So you telling me I don't have the right to do a verbal motion?
You don't have a right to do that. You're gonna file it in writing and you're gonna serve it properly on.
The key issue here is procedure, not belief. The defendant is trying to challenge jurisdiction, but the court is requiring a written motion properly filed and served. That matters because even a valid legal argument can fail if it never reaches the court through the procedure required to hear it.
The parties that you're filing it against, okay, sir? March 14th at 10:30 in person at the court will be the date for the formal hearing, and then we'll hear any arguments on motions if necessary. Do you have any questions today, Mr. L? Okay, well, then you're all set. Thank you. Okay, you can have a seat. Thank you. Today's the date and time set for a formal hearing. I have, I believe, one witness on Zoom. Counsel, you can proceed.
Officer Vanderwerf, would you state your name for the records, please?
Oh, you want to call him? Let me.
Oh, I'm sorry.
Sorry, man, no worries. Vanderwerf, can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, Judge. So I was traveling southbound on King when I observed a pickup truck in front of me that was changing lanes, failing to use its signal. So at that time, I activated my overhead lights on the vehicle to initiate a traffic stop. And then I made contact with the driver, who was later identified as a Rambo L. In our contact, he ended up handing me a piece of paper. At brief glance, when I looked at the piece of paper, it appeared to have what I believe was certain MCL codes that the subject may have typed onto the piece of paper. When I had asked him for a driver's license or identification, he was not really very cooperative. I also don't believe I was provided any insurance. At that time, I decided to issue him a citation for failing to signal, changing lanes, and failing to display a valid license, and then also the license plate through the system was expired.
Mr. L, did you want to question the witness?
Yes. The document that you were referring to, it was a travel document. I was showing you, I was traveling versus driving, and I tried to explain that to you. And then you held me on the side of the road for approximately an hour. I requested a supervisor because they might better understand what I was doing, and you never provided that for me. Is that correct?
That's actually incorrect, because the reason that you were held on the stop for as long as you were is because I was waiting for a supervisor. So when I realized the supervisor was not there, I contacted him by phone, at which time he said he was delayed. And when I came back up to the traffic stop, I did ask if you wanted to wait further for a sergeant, and I don't believe that you did. And then you drove off when you were free to go.
Yes. Is it correct that I was held on the road for approximately an hour waiting for this whole encounter to end?
I do not remember if it was an hour specifically, but I do remember that the time length was probably, I would say probably close to that at the very least.
Well, it was an hour, and it caused me to be late for my son's banquet. And and I never got to speak to a supervisor. That's all the questions I had.
Okay, any redirects?
No redirect, Your Honor.
Okay, any additional witnesses today?
None from the city.
Okay, Mr. Earl, are you calling any witnesses today, or did you want to give your own testimony?
I would like to, I have some, I have a defense, my
Well-
motion.
Okay, well, you filed a motion?
Yeah, I filed a motion, served across
When did
city
you file a
attorney.
motion?
It was filed, it was mailed February 18th.
You filed a motion and mailed it February 18th. Did you serve a copy?
To the clerk of the courts and also to the city attorney's office.
Did you receive any motion, sir?
Your Honor, we did receive a motion. It did not have any hearing date stated on it. We had no timetable for a response. I would be happy to respond to the motion on the record orally or provide the court with briefing if they would like.
The court didn't get a copy of the motion in February.
I sent it to the clerk. And,
Yeah, typically when that happens, it's just attached to the file. I don't have a copy of any motion.
Well, I did my due diligence. I sent a copy to him. He has his.
Well, I don't know that you did your due diligence because when you file a motion, you got to get a hearing date for that motion. And so
Who's supposed to give me a hearing?
you got to get the hearing date from the clerk's office.
From the clerk's office?
Yeah.
So why did they give me one?
Did you contact them for a hearing date?
I contacted them, yeah.
And asked for
And I
hearing
asked
dates
them,
for your
and I
motion?
asked them when was my hearing. They confirmed that it was today.
For your motion.
And I asked, did I have a hearing date? And they
But-
said,
And you do have a hearing date, but that's not what I asked you. Did you ask them, did you have a hearing date for your motion?
for my motion,
Yes.
they didn't tell me, but I did provide to him an order for the motion that gave him 21 days to respond.
Okay, you can make your motion before the court because I don't have a copy. You can make it now orally.
Okay, well, now comes the beneficiary for Rambo L, defendant in error, here by special appearance, not submitting to the court's jurisdiction, hereby moves the court to strike and dismiss the complaint filed by the officer, Zenderbar, am I pronouncing that right? Sorry if I'm not, for lack of ratification and commencement, no corpus delicti, no plaintiff, lacks jurisdiction, personal, firm jurisdiction. Kristen Simmons being appointed as trustee, the prosecutors being appointed as co-trustee, I, Rambo L, an executor and beneficiary of a set of account. Also, I filed a declaration of non-citizenship nationality because I've done a name change. Where my point of authorities are the United States District of Columbia Corporation in Volume 20, Corpus Juris Section 1785, we find United States government as a foreign corporations with respect to the states. Since the corporation is fictitious, is a fictitious person, it can't see, speak, smell, or touch itself. It's a fiction in the real world. It needs a conducting, transmitting utility, a liaison, some sort of connection to a fictional person. Constitutional Amendment number 1, Congress shall make no law respecting an establishment of a religion, prohibiting free exercise thereof, abridging freedom of speech or right of press or right of people peaceful assemble, petition the government for redress of grievance. Number 5, Constitutional Amendment. The right of people should be secure in their person, houses, papers, and effect against unreasonable searches and seizures shall not be violated, and no warrant shall be issued upon probable cause supported by an oath or affirmation, particularly describing the place search of persons, things to be seized. And then number 7, Constitutional Amendment, suits at common law where value of controversy exceeding $20, the right of a jury trial shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States according to the rules of common law. I asked for a jury trial, I didn't get that. Rambo L is a man, people, but not a person. I was not operating in commerce, nor was I a driver on the road for travel. A driver is an employee transporting goods or passengers. Rambo was just merely traveling in my private property. Here are some examples of my Supreme Court constitutional defenses. Case number one, the right to travel is part of a liberty where where a citizen cannot be deprived of due process under the Fifth Amendment, Kent versus Duels, 357 U.S. 116, 125. Case number 2, I have the right to travel freely and unencumbered pursuant to Shapiro versus Thomas, 394 U.S. P. 618. That right is so basic, it doesn't even need to be mentioned. The state of Michigan arbitrarily and erroneously perverted my right into a privilege and issue a license and a fee for it. Murdoch versus Pennsylvania, 319 U.S. 105. Supreme Court trumps everything. Says that no state can convert a secured liberty into a privilege and issue a license and fee for it. Case number 4, Shuttle versus Birmingham, Alabama. It shows that I can ignore a license and engage in the right with a community. Case number 5, Marbury versus Madison, 5 U.S. 137, shows that any law in violation of the Constitution is null and void. Case number 6, Shuttleworth versus Birmingham, 373 U.S. 262, says I may ignore the license and the fee and engage with the right with the immunity. That means you can't punish me. And United States versus Bishop defines willfulness as an evil motive or intent to avoid a known duty task under the law with a morality certain. I submit I couldn't have been doing an evil task. I totally followed the Constitution in the Supreme Court. Briars versus United States says it shows how the judge is supposed to interpret the Constitution, and it's supposed to be interpreted in the favor of me. A.M. Jurisprudence, Volume 16, Section 97 of the Constitutional Law section says it should be received as a liberal interpretation in favor of the citizen, especially true with respect to those who were designated to safeguard the liberty and security of a citizen in regards to both persons and property. See note 31, Briars versus United States. No state may convert a liberty into a privilege. Murdoch versus Pennsylvania. An appearance ticket is not accusatory instrument. It doesn't confer jurisdiction over the defendant. People versus Gabay, 670 New York 2D 92517. I was not engaged in a commercial trade at the time of the alleged infraction, and I do not proceed to say a license is upon a constitutional detention. Motor vehicle means every description of a carrier drawn by mechanical power used in commercial purposes on a highway. There's neither injury nor trespasses, any trespasses. All crimes are commercial, 27 CFR 72.11, and every alleged crime has to have a nature and cause and be prosecuted by the name of the people of the state. I don't have a contract with the state. I don't see an injured party. I don't know why I'm here.
Any additional
I
argument on your motion?
would like the court, I would ask the court to dismiss this to failure to state a claim where relief can be granted.
The court has heard the argument. I'm first address your motion, Mr. L, and I'm going to deny your motion as clearly indicated in the response by the city. Your claims would be most appropriately brought before the Court of Claims, and so you can't challenge a constitutional issue in this court, okay? As it relates to the authority and the process to bring this matter before the district court as it relates to your civil infractions, you have an expired plate and a failure to signal. Again, a jurisdiction or venue before this court is appropriate. This is a situation or incident that occurred in the area of South MLK, Martin Luther King Boulevard. That's in the city of Lansing, Ingham County, state of Michigan. And so you're subject to the laws and the ordinances of the city of Lansing, but also the laws under the Michigan compiled laws. Here in this district court, we are subject to the Michigan court rules. And so although I gave leniency with your motion, it was not properly filed and or served. But it also does not comport with the Michigan compile laws or Michigan court rules. And so for those reasons, it is denied. Now, as to the civil infraction, failed to signal an expired plate from December 3rd, 2022, we did not provide any valid dispute or defense to these civil infractions. You could have appeared and showed information that demonstrated you did have a valid plate at the time, or that you even have one now, which could reduce the citation, but that's not taking place. And so I'm going to sustain both violations of civil infractions. There's a fine of $125 on each. Okay, sir?
My next defense, so I'm just done, or can I say something else?
You can say something else. I actually, if you had any further defense, but you said.
My next defense would be, Michigan allows 72 hours to register any vehicle when it's first purchased. He never asked for anything. I never got a chance to explain myself on the side of the road.
Okay, do you have proof that you had just purchased it within 72 hours?
I don't have the title.
Okay, thank you, sir. If the defense is not meaningful, if you can't provide any evidence to support that defense. That being said, your fine is $125 on each file. When do you intend to make payment?
Do I have a chance to appeal this?
You can.
I would like to appeal.
Okay, you want to file an appeal as to the civil infraction?
I want to file an appeal today.
Okay, you can file a motion for reconsideration. But you need to follow the Michigan court rules, okay? We don't submit to the sovereign rules, okay? This is, you take that to the sovereign court. On the record in the matter of the people of the state of Michigan versus Gennaro Edwards, file number 23-00747, counsel appearance.
Brian Ring on behalf of the people.
Somebody represent me.
I'm sorry?
I didn't understand how somebody represent me and I'm representing myself.
No
And
one
I
has-
can't see
no one
myself
said that they were
on Zoom.
Nobody said they were representing you.
Oh, I thought that's
He
what
said,
you just.
he said
I thought that's,
he was here on behalf of the people.
oh, okay, my fault. I'm sorry, Your Honor.
Okay. You wish to represent yourself, sir?
Yes, ma'am.
Okay, and why
I
is
can't
that?
see myself on the screen.
Okay. Are you under the influence of anything at this time?
No, ma'am.
Okay. I don't know why you can't see yourself on the screen.
I could just hear me and see you.
Okay.
But that's
Are
okay.
you-
That's okay. That's okay.
Okay. Okay, so you understand, sir, that you do have the right to have court-appointed counsel represented at the expense of the public if you cannot afford to hire an attorney?
Yeah. Yes.
Okay, and you wish to waive that, you say?
Yes, ma'am. Oh, and
You know what?
one more
Mr.
other
Edwards,
thing,
you need to
ma'am.
appear in person. You need to appear in person today, okay?
How was I supposed to appear in person? I live in East Point, Michigan. That's down there by Detroit. I've been served a summons felony and not a complaint felony. I don't know what's going on, ma'am, and I want to avert the jurisdiction and read my warrant into record.
Okay.
I
well,
don't
you
know
need to do
what's
that
going
in the
on, ma'am,
courtroom,
and
okay?
I know, and I understand this Zoom is illegal according to Tyler versus Illinois for US 400. I know it is. So I know I have to report, but you're going to have to give me some time because I don't have transportation.
Okay, when are you gonna get here?
You're going to have to at least give me a month. You're going to have to at least.
No, you're not getting a month.
I
You got a court date on the 13th.
I can't make it. I can't
Oh,
make it.
okay, well, then you'll get a warrant, okay?
I'm asking the court
If you don't
to
appear on
adjourn
the
it until
13th, you'll have a warrant for your arrest. We're not giving you a month to show up to court.
Ma'am, I'm asking the
Do
court
you have
to
any
adjourn.
questions at this time?
Yes.
What's your question, sir? I'm happy to answer them, but what I won't do is go back and forth with you about nonsense, okay?
Okay, yes. All right. I have a quorum warrant. May I read it into record?
I'm sorry, you have what?
I have a cornrow of worn toe. I have a cornrow of worn toe. I have a cornrow of worn toe. Cornrow of worn toe is QUO, worn toe. And I have lack of jurisdiction and a motion to dismiss.
Okay, gotcha. Yeah, you need to file that with the court and serve it on the prosecutor. We're not reading that on the record today, okay?
We can't read it. All right. Well, since
No,
we
you
can't
need to
read it
file
on
it
the
with the
record,
court. You need to do an appropriate filing, and then you serve the prosecutor, okay?
I will, ma'am. But I have one more other thing. Since this is probable cause, can you at least let me know what my charges is and who is lodging the charges against?
Yeah, did you appear for your arraignment on March 8th?
Yes, I did, ma'am. And they put me on a
were
personal
you advised
bond.
at the time of what you were being charged with?
She said something about larceny, but she didn't say from who.
That's exactly what you're being charged with, a larceny.
Yeah, right, but she didn't say from who.
You're being charged by the people of the state of Michigan for count 1 on or about August 19, 2022 through August 20th, 2022 at the area of 4600 Collins Road, City of Lansing, Ingham County, State of Michigan, for allegedly committing the act in count 1 of larceny, $1,000 or more, but less than $20,000. It alleges that you did commit the offense of larceny by stealing money that belonged to Avonshire. The value of the property stolen $1,000 or more, but less than $20,000. This was contrary to Michigan Compile Law 750.356(3)(a). That's a felony. Maximum penalty 5 years and or $10,000 in fines, or 3 times the value of the stolen property, whichever is greater. To impose a fine of 3 times the value, the defendant must admit the amount, or it must be determined by a trier of fact at trial. There's an habitual offender, 4th offense notice. So that would enhance the maximum penalty on this. It says, take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about May 11, 2016, he was convicted of the offense of failure to return rented property, $1,000 to $20,000, in violation of MCL 750.36583A in the 16th Circuit Court of Macomb County. And that on or about March 7th, 1997, he was convicted of the offense of delivering, manufacturing less than 50 grams in violation of MCL 333.74012A4 in the 4th Circuit Court of Jackson County. And that on or about March 7th, 1997, he was convicted of the offense of carrying a concealed weapon in violation of MCL 750.224 in the 4th Circuit Court of Jackson County. And that on or about March 7th, 1997, he was convicted of the offense of felon in possession in violation of MCL 750.224F in the 4th Circuit Court of Jackson County. And that on or about February 5th, 1993, he was convicted of delivering, manufacturing less than 50 grams in violation of MCL 333.7401224A in the 31st Circuit Court of St. Clair County. And that on or about March 14th, 1991, he was convicted of the offense of delivering, manufacturing less than 50 grams in violation of MCL 333.7401224A in the 4th Circuit of Jackson County. And that on or about August 5th, 1991, he was convicted of the offense of delivering, manufacturing less than 50 grams and contrary to MCL 333.7401224A in the 31st Circuit Court, St. Clair. And that therefore the penalties are a maximum of life if the primary offense was 5 years or more, or 15 years or less if the primary offense has a penalty of under 5 years. This is again a larceny with the maximum penalty of 5 years. So you are facing life as a maximum penalty. I ask you again, do you want court-appointed counsel?
Okay, ma'am. I wanna interject that the MCR 404B1 says you have to show conformity to the habitual, and there's no conformity, and is over 10
This
years
is a probable
old.
cause conference. We don't have to
It's
show
over
any
10 years
conformity at a
old, man.
probable cause conference. So this is what we're gonna do. We're gonna see you in person next week, okay, sir?
I can't make it.
Well, if you don't make it, guess what's gonna happen? A bench warrant will issue. You go ahead and have a good day. I got other cases to handle.
Can I call up my witnesses for next week?
Across these proceedings, the same strategic problem keeps appearing. The defendants focus heavily on changing the language of the case instead of using the legal procedures available to them. In Case 1, the defendant repeatedly challenged jurisdiction by separating the living woman from the name used in the case. But the court still presented clear procedural choices: work with an attorney, speak with the city, or proceed toward a jury trial. The important point is that disagreeing with the court's jurisdiction does not automatically create a fourth option where the proceeding stops. In Case 2 shows the same problem from another angle. One defendant relied on arguments about sovereignty, nationality, the right to travel, and the distinction between a person and a legal fiction. Another attempted to challenge jurisdiction through documents that the court said were not properly filed or served. The court did not have to debate every theory. It could simply apply the rules governing how motions must be presented. That is where the strategy becomes costly. A defendant may believe that refusing the court's framework protects their rights, but a courtroom still operates through recognized procedures. A motion has to be filed. Parties have to receive it. A hearing may have to be scheduled. Evidence has to support factual defenses. And when the court gives a defendant an opportunity to present a legally recognized defense, that opportunity has to be used effectively. The traffic case makes that especially clear. The defendant eventually raised a defense involving the 72-hour registration rule, but when asked for evidence that the vehicle had actually been purchased within that period, he could not provide the title. The court therefore rejected the defense and imposed the stated fines. The criminal case goes even further. The judge explained the charge and the possible enhanced penalty, including the potential maximum exposure described on the record. Yet the defendant continued directing the discussion toward jurisdiction and procedural objections rather than addressing the immediate requirement to appear. None of this proves that every underlying argument was intentionally frivolous. It shows something more practical. A courtroom rewards arguments that can be connected to the rules, evidence, and procedure actually governing the case. When that connection is missing, repeating the same theory does not make it stronger. It can simply leave less time to address the issues that can actually change the outcome.